Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good morning to all my beloved students. So today our lecture is on the subject of privity to a contract, under law of a contract. So the objective, there are 4 objectives that we need to go through, which is already in your slide. So just go first, the meaning of privity of a contract. What is the meaning? Apa maknanya? As a general rule, contractual rights and liabilities affect only the parties to the contract, and a person who is not a party can neither sue nor be sued or on the contract. That means sebagai general rule, undang-undang biasa, tapi nanti kita ada tengok exception to the general rule. Jadi kalau kita belajar kontrak ni, undang-undang biasa, general rule, ada satu, kemudian kita kata exceptional to the general rule. Itu kita kena faham daripada awal. Nanti kita tengok, ni ada pula, there's something yang tak sama pula ikut general rule, ya. Jadi kena keep your mind, there's only some rule which is exceptional to the general rule. So sebagai general rule, those people in the contract only can sue or be sued. There's no other people outside the contract can be a party to be sued or not to be sued. Saya have agreement dengan Balkis. Jadi kalau apa-apa pun, if anything, I have to suit with me a Balkis, or Balkis can sue me. Khatijah or Manja or whatever cannot be a party to the suit. Suddenly pula Manja ke siapa ke datang, dia nak masuk campur in the suit, cannot. So privity contract mean only those party to a contract. Other than that, cannot be involved in any litigation or any suit. Second one, a contract cannot usually give rights or impose obligation on anyone who is not a party to the contract. Saya berkontrak with Miss Balkis, so if Miss Balkis supposed to deliver me his car and she doesn't deliver, so I cannot force Khadijah to deliver her car to me. Nampak tak? Cannot be, kan? So this is the 2 main rules of a privity of a contract. Yeah? 2 main rules. Only 2 party can be sued, and if any other obligation, we cannot force another party which are not to the party correct to fulfill the obligation. You beli buku from kedai buku ni, suddenly kedai buku tu tak deliver. Now you force another bookstore to give you the book. You can't, because they're not a privity to the contract or party to the contract. So when they're not party to the contract, they are not privity to the contract. So those 2 rules is very important that you need to understand today, for this lecture. These 2 rules is a fundamental principle of a common law. You forget, common law is the law that we used to follow from the British punya government punya law. Jangan dulu saya tanya common law, ada yang jawab undang bersama-sama. Susah. Dulu ada dah ajar, so jangan buat lagi cerita. Kalau dalam exam, we ask what is common law, and your answer is undang bersama-sama. Then you really looking for trouble. So under this common law, iaitu undang-undang British yang kita ikut, the British law that we are following here, before we create our own parliament, before we have our own laws, a person who is not a party to a contract has no right to sue to the contract. Ada sebut tadi. An example pun ada sebut. So I won't go with that, it's all in the notes. So the 2 common law principle, he's a party. He give consideration to defendant in return for his promise. Kalau kita dah belajar tu, mesti ada 2 party, offer and acceptance, and must be consideration. Then only the contract law is binding, or the contract is binding. The position of the third parties is that obligation under a contract cannot be transferred unless all party consent. As I said just now, I have a contract with Balkis for her to deliver me the car, and I pay consideration to that. But then he don't have the car to deliver, so we agree that both of us agree that Khadijah now should deliver me the car. So if both agrees and Khadijah agreed to deliver first, later maybe he has arrangement with Balkis, I don't know, because we are not party to the contract. That can be done. So this is the exceptional to the general rule. So in this case, we call it exceptional to the general rule, which only two parties can be in the contract. But both of us agree that Khadijah deliver her car first, and she also agree to give us, then the contract can be completed. Yeah, that means completed. And two parties berkontrak. Party supposed to deliver the car, but he don't have the car yet. Another party deliver the car. So the contract with me and Balkis is completed, provided all the three parties agree. Yeah. So there's some British case there you can go through, and what is the help? When the help put down help, mean that is the court decision. Apa keputusan mahkamah? So you can read there. If any don't understand, you can ask Mr. Balkis to explain, or you can email me. But we have one good example there. I just want to highlight is the Dunlop case, Dunlop Humanity Tire. In the contract, you and company, the wholesaler agreed to buy tires from Dunlop. Satu kedai tire, a tire shop agreed to buy tire from Dunlop. Dunlop is a manufacturer of the tire. Yeah, Dunlop is a manufacturer of the tire. This tire shop agreed to buy the tire from Dunlop. Okay, so what happened? They did so on the express undertaking that they would not sell below certain fixed price. Dunlop kata, okay, I give you this tire to sell in your shop, let's say 100 ringgit, but you cannot sell below 100 ringgit. Why Dunlop do that? Because they may have other shops, other agents also, that they cannot, minimum sale price must be 100, so that no competition. Yeah, they should sell all Dunlop price as a same price, one shop to another shop, because Dunlop sell the tires to a lot of tire shop. So what happened to the Dew and Company, the tire shop just now? What happened? They also undertook to obtain some same price fixing agreement with their client. Dew sold tires to Selfridge. Dew pula sell tire ni ke another shops, Selfridge. On this term, but Selfridge broke the agreement and sold tires at discount price. Selfridge ni kalau dekat Malaysia ni macam Jaya Sko, Ion. Kedai shopping complex lah. But shopping complex, sometimes you go to shopping complex, you buy the shirt or you buy something outside maybe 100 ringgit, but the shopping complex sold 90 ringgit. It's up to them because of their marketing strategy. So this shopping complex, Selfridge, supposed to sell the Dunlop tire at 100 ringgit, now he sell at 90 ringgit. So the Selfridge broke the agreement because he sold 90 ringgit at a discount price. Supposed to be 100 ringgit, now he sell at 90 ringgit. So what happened? So Dunlop sought injunction. What is injunction? Dunlop sought injunction. He go to the court and ask the court to stop Selfridge from selling 90 ringgit. So they call it injunction. Yeah? So what happened? The court held that yes, because Dunlop has an agreement with Dew and Company that they only can sell Dunlop price, tire price at 100 ringgit. Now because Selfridge is selling below 90 ringgit, so the court held bagi keputusan that yes, now Selfridge cannot sell the thing at 90 ringgit. So this is how we call it a privity to contract. You can see, although Selfridge is not a party to the main contract, because if you are party to the main contract, very simple, Dunlop just can terminate Selfridge. But Selfridge contract is with Dew and Company. So Dunlop has no agreement dengan Selfridge. So he has to go to the court to ask the court to stop Selfridge from selling below the fixed price. So it still can happen in case you are not a privity to contract. You still can ask the court to have the injunction or to give the court order. So this is normally we call it exceptional to the normal contract. You you still can go to the court to ask for your judgment. So what is the jus quaestitum tertio? This is a Latin word, not to worry. A contract cannot confer rights on a third party, and only a party to a contract can sue on it. So in this case just now, the Dunlop has already give a rights agreement to due. So due cannot give that rights to another party, self-register. So there is the principle in jus quaestitum tertio. But rights may be conferred on third party by way of trust, if so intended. Tetapi due tadi can give to self-register if they have to do some agreement, we call it trust, and must be agreed by Dunlop punya tire manufacturer. So that's the principle of that law. Only binds the parties on a contract. A person not party a contract cannot. Ini kita dah sebut banyak kali tadi. So it's only bind for those in contract, not in contract, tak boleh terlibat. So there's a case of Mac Grutter. Just read. It's a similar case. ABDUL in this case is similar case to show how not people privity a contract cannot involve in the contract. So it's all cases that you can read, and it's the same thing, but different cases, different scenario. So the more cases you read, the more understanding you will have on the privity of the contract. Collateral contract. A contract between two parties may be accompanied by a collateral contract between one of them and a third person relating to the same subject matter. A third party may also be pursue concurrent action on top. So, what is collateral contract? So, if two party, like say just now I said, I with Bakis have a contract, but then we can add additional, what we call a collateral contract, tambahan daripada the main contract, and then those collateral contract is all party agree, then it become a collateral contract, and that contract all the three party can be sued or to be sued on if any default on the contract. So this collateral contract is normally additional contract from the normal contract, because after we sign something, sometimes we need more people to be a party. Macam tadi lah beli kereta tadi, kita sebut that now Khatijah can deliver a car. Actually there must be a collateral contract, then only she can deliver the car to me, and she may have another contract with Bakis. When Bakis got the car or new car, she will give back to Khadijah. So same thing like case of Donio and Stevenson, is also the same thing. It's talking about this Mr. Stevenson this one is donation upon showing physical damage, indirectly trespass, a person indirectly trespass the case. Ini sama, because Donnie Stevenson punya rumah sebelah-sebelah, and then dia ada simpan chemical, and then the chemical tu macam acid pecah, then go to the rumah yang sebelah. So rumah sebelah tu still can sue walaupun dia tidak ada kontrak dengan apa. You can read that one, it's not much problem. Price and Eastern, another interesting case. Eastern agreed to do certain work. Ini senang sikit example. Dan the Donnie tadi susah sikit. But I give you a simple one. Eastern agreed to do certain work in condition of which would pay specific sum of price to third party. The work was done, however, Eastern failed to pay the price. Price tried to suit enforce the contract, but found his claim unsuccessful because she was not a party. Ini case macam tadi. If the person ni not a party the contract, dia suruh you buat, and then you nak claim duit, katalah I suruh satu orang cat rumah, tapi orang tu pula suruh orang lain cat rumah, and then tukang rumah ni, the house ni didn't pay the money to the person yang cat rumah. So now yang third party nak cat rumah tadi want to sue me, cannot, because I don't have a agreement with him. So this is very important for you to understand, because later on if somebody asks you to do anything, make sure you have a contract with the person. Satu orang say that I have to repair my house, to give to Mr. A atau give to Balkis. So the Balkis not busy, so she asked Mr. C or Ija to do the repair. So Ija repair the house. Now the owner refuse to pay Ija. So Ija cannot sue me because my contract is with Balkis. What Ija can do, if she has a contract with Balkis, she only can sue Balkis, but she cannot sue me. So this is the example like Price and Eastern case lah. Agency. Concept of agency, exception of doctrine of privity, then agent may contract on behalf of his principal with third party. Ni agency ni ada different than normal contract because let's say now Proton give me an agency to sell his car. So now I'm the agency. I have a contract with Proton to sell his car. So he send the car to my place. So when I sell the car, so I act as an agency. So there's no contract between Proton and the buyer. The contract between me and the buyer. So we call it in this situation agency contract. So this is the example of agency. Then we have trust. Trust in simple, I can mention here. Let's say now I want to give some property to my grandchildren. My grandchildren is still small. So I have to appoint somebody as a trust. Maybe my brother, my sister say that when my grandchildren grows, when they come at age of 18, so you give back the land to my grandchildren. Contoh macam tu lah. So now the person that I give the right, because I want to die already, I want to move to other country, I won't be here, I'm not going to see my grandchildren in future maybe. So this guy who we give him the authority to take over charge of property, we call it trust. So there's a trust law, you can go to the lawyer, they will prepare everything, so this person acts as a trust. So he cannot use the property, he cannot sell the property, he cannot do, he just hold it until when this children grows big, when the age of majority, 18, then according to the trust, you transfer to them. So it's another way of a contract, but we call it trust, because that party is not a privity to the contract. Restrictive covenant. Restrictive covenant means if certain conditions are satisfied, run with the land and bind purchase if observe the covenant or prohibit of adjoining owners. So in the agreement, you can also have additional restrictive covenant. Covenant is condition. Another way, sometimes you see in the agreement, they say the condition. Sometimes the lawyer put covenant. Both are the same thing. So it can be restrictive. You said, I give you this land or I sell this land only to build a mosque, masjid. So you sell the land, they cannot use to build houses or other things. They only can use for masjid. So you can put restrictive in the agreement. I sell this land for you to build road. So they only can buy your land to build road. They cannot use the land for doing commercial house or shop or kind of thing. So you can put a restrictive covenant, or we call it condition, in your agreement. Statutes. The last one, statute. Certain exceptions to doctrine of privity have been created by statute. But again, doctrine of privity, only two party contract can get involved, not the third party. But there are laws. Statute means laws passed by the government, including price maintenance agreement and certain contract of insurance enforceable in favor of the third parties. So sometimes you buy insurance, then the law said, okay, if this fellow accident, they lost one leg, the insurance have to pay 10,000 ringgit. So that means even the insurance, you buy the insurance contract, but the amount is stated in the statute, in the law. So the insurance have to follow the statute to award the compensation. Cannot say that, okay, you buy my insurance, if you break or lost your arm, I pay you 100 ringgit. Tak boleh. Because the law said 10,000 ringgit. So the insurance have to follow the statute. Even you want to make a privy contract to both parties to pay 100 ringgit or 200 ringgit, cannot, because the statute say 10,000 ringgit. So this is again exception to the general rule. That means exception to the privity of contract that you can both agree to pay. Now cannot, because the law, statute means government passed the law like that. If they die, the accident, you have to pay 100,000 ringgit. You cannot have a privity to a contract to pay. If he died, the insurance will pay 1,000 ringgit. Tak boleh. So this is called it exceptional to the general rule. Yeah. So that's the summary that I given you all today. Definition of privity. That means only two party can be to the contract. And then identify the principle of the privity. The principle must be those who involve, not any other party. Define and use question ratio, I already explained just now. And then understand the exception. Exception is very important because there's always law, statute, guideline, the government laws that you cannot put in a contract. For example, can we sign a contract to sell guns? Cannot, because the law said gun is illegal. So that is why we call it exception of the contract. So you cannot simply sign any contract if there's a law statute say no. Yeah. So that's my lecture for today, and we hope you enjoy it. And you don't understand, you can email me or ask your lecture. Thank you very much. Assalamualaikum.